morning, this is Representative Carpenter, and this is Saturday, March 9th, and this is a capital update from Juneau. This morning, I want to talk to you a little bit about grand juries. This is a mysterious part of our judicial system, but it's an important part. And recent history has identified a need to reform our grand jury process. And there's been some recent activity that I'll go into that causes us to bring this amendment forward. I wanted to start with just a little bit of education here. Grand juries is found, the power for grand juries is found in our Alaska state constitution. So the power of the grand jury is found not in the courts section of the Constitution. It's not found in the legislative branch of the Constitution. It's not found in the executive branch of the Constitution. It's found in Article 1 of the Constitution, where our individual rights are found. It's under Article 1, Declaration of Rights for Alaskans. It's specifically right underneath the section that talks about due process rights. Section 7 is about due process. Section 8 is about grand juries. Specifically, it's found in Section 8, right below Section 7, which is due process. And the constitutional provision of which we're talking about, and I'm going to quote from the Constitution, says, "No person shall be held for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the armed forces in time of war or public danger. Indictment may be waived by the accused. In that case, the prosecution shall be by information. The grand jury shall consist of at least 12 citizens, a majority of whom concurring may return an indictment. The power of grand juries to investigate and make recommendations concerning the public welfare or safety shall never be suspended." So the Constitution sets up the rights for a grand jury. Alaska statute, section 12, chapter 40, speaks about grand jury powers in statute, and criminal rules 6 and 6.1 of the court rules speak about the process for grand juries. And if you've ever served on a grand jury, then you'll know that one of the first things that happens is you get sworn in as a grand juror. And your time of service on a grand jury is lengthy. It could be up to 4 months, and it could be longer if the presiding judge extends it. And normally, under normal procedures, you meet every week to consider what the DA, the district attorney, or the prosecuting attorney has to bring to the grand jury to consider with regard to indictments. But your oath that you take, in part, says that you will solemnly swear to or affirm that you will diligently inquire and true presentment make of all such matters as shall be given to you for consideration, that's by the prosecutor, or shall otherwise come to your knowledge in connection with your present service, which is information that may come to you not through a prosecutor. It continues on that you will present all things truly and impartially, as they shall come to your knowledge according to the best of your understanding. So as a member of the grand jury, and that's a member of 12 to 18 members, you have a responsibility to decide whether you're going to deprive a citizen of their liberty on suspicion of a capital crime or a felony crime. You also have a responsibility to investigate matters that are brought to your attention. In the statute, this is reinforced. AS 1240-030 says the grand jury shall inquire into all crimes committed or triable within the jurisdiction of the court and present them to the court. The grand jury shall have the power to investigate and make recommendations concerning the public welfare or safety. The statute continues into AS 1240-040. If an individual grand juror knows or has reason to believe that a crime has been committed that is triable by the court, the juror shall disclose it to the other grand jurors who shall investigate it. The grand jury, and this is section 050, the grand jury may indict a person for a crime upon sufficient evidence, whether that person has been held or arrested for the crime or not. Section 12.4.060. The grand jury is entitled to access at all reasonable times to the public jails and prisons, to offices pertaining to the courts of justice, and to all other public offices, and to the examination of all public records in the state. So the grand jury has access to everything public, all public records in regards to their investigation. And section 1240.070 speaks to the duty of the prosecuting attorney. One speaks to when the DA submits an indictment after a person has been arrested for a crime, and the grand jury reviews the indictment on whether they should proceed to trial. Section 2, subsection 2 of that same statute gives the DA discretion to submit an indictment causing someone to be arrested. And then section 3 is specifically says that the DA shall, when required by the grand jury, prepare indictments or presentments for them and attend their sittings to advise them in relation to their duties or to examine witnesses in their presence. So this subsection is when the grand jury is presented with information that they determine warrants an indictment, that the grand jury may direct the prosecuting attorney to cause that indictment to come forward. Well, this is the subsection that has recently been thwarted by judicial officers and officers of the court, right? That's the judges and the district attorneys. They have prevented members of the grand jury from presenting information to the other grand jurors so that they could decide to investigate. It's very clearly a violation of the oath of office, the oath that the grand jurors take when they are sworn in. It's a violation of the Constitution. It's a violation of the statutes. This week, we amended into HB 67, which was a victims' rights bill, clarification of statute. That clarification was that grand juries have the right to investigate and direct an indictment be prepared, or produce a report on the public welfare and safety. And that may include some allegations of wrongdoing. It also clarified that grand jurors and members of the public have a right to present information to the grand jury. And it makes the grand jury responsible for deciding what to investigate and what not to investigate. And if you really stop to think about this, what's happening is one or two individuals, judge or prosecuting attorney mostly, that single individual, or maybe it's a group of attorneys within the Department of Law's process, are making a decision as to what information the grand jury can have or not. But that grand jury, which is a majority of the grand jurors, somewhere between 12 and 18 members of the public, are allowed, have a responsibility to deprive our citizens of their liberty for a suspicion of criminal wrongdoing. So those grand jurors can be trusted to determine what needs to be investigated and what is considered public welfare and safety. If they can't, then why are we trusting them to indict somebody for a capital crime? We've also clarified in statute the protection of due process rights for the accused. And this is something that the Department of Law brought up through our discussions with them. And we worked very diligently to try to craft this legislation with their input. When a grand jury is conducting an investigation and they come upon information that is indictable, meaning it's information that is admissible in court and presents a suspicion that somebody has actually committed a crime, then the grand jury can direct that a second grand jury be impaneled in order to consider the indictable information, the admissible information, so that the grand jury, if it had considered non-admissible information, that that indictment wouldn't be tainted. And this is to protect the due process rights of Alaskans. We also increase the protection of victims by putting in statute that victims don't have to appear in front of a grand jury, meaning the grand jury can accept information that would previously be considered hearsay if that sworn testimony is going to be presented at trial, and the individual presenting that information will be available at trial. This is to prevent the re-victimization of folks that have just went through a crime. Maybe it's sexual assault or some other really difficult crime, and they don't really want to come to the grand jury within short time frame. So the testimony that they have given to law enforcement is acceptable to be presented to the grand jury under this new statute. We've also made it a Class A misdemeanor to question a grand juror for anything they say to a grand jury. And we've also made it a Class A misdemeanor for obstructing a grand jury from conducting an investigation. And this is important because the current statutes have been violated. They've been violated on the record. I've listened to the recordings where both judicial officers and officers of the court have prevented grand jurors from presenting information to grand juries. It's important that we put some teeth into these two provisions so that those individuals who try to prevent a grand jury from investigating something can actually be held accountable. We're going to have a challenge with getting the rest of these grand jury provisions through the legislative process, as it is not something without additional cost financially in the budget, and it is not without its challenges in the Department of Law and the courts reworking their processes, everyday processes, to allow grand juries to do what they're constitutionally and statutorily obligated and allowed to do. That's a difficult thing for the bureaucracy to want to do. And so there's going to be continued pushback on accepting these grand jury provisions from the Department of Law. So it's going to be a challenge to move forward, but we're going to keep on top of it because it's the right thing to do. Even if it can cost a little bit more money and it is a little bit more work, victims in this state need to know that Alaskans have their back and that the grand jury is able to investigate even when a prosecutor is not interested in doing so. So we will keep you updated on this as the session progresses. And if you have any questions, you can reach out to me. Phone number is 907-465-3779, and you can email me at rep.ben.carpenter@akleg.gov. So this is Representative Carpenter signing out from Juneau.